Good morning, everybody, and welcome to the District of Columbia Court of Appeals. We have 3 cases on this morning's, I guess it's a special sitting because it's been rescheduled from a previous date. And our first case is going to be a little unusual because we have Mr. Davidson appearing remotely. Can you hear us, Mr. Davidson?
Yes, I can, Your Honor.
Okay, so hopefully this will go well. The first case is number 24 TX 500 Milton A. Barlow Jr. versus District of Columbia. Whenever you're ready, Mr. Davidson.
Thank you. May it please the court. My name is Kerry J. Davidson, and I represent appellate Milton A. Barlow Jr. in this matter, appealing the Superior Court's grant of summary judgment in favor of the District of Columbia's Office of Tax and Revenue. I'm going to refer to Mr. Milton Barlow as Allen, the appellant, to distinguish him from his father, Milton A. Barlow Sr., who is the grantor of the trust at issue in this case. And that trust is titled the Milton A. Barlow Sr. Revocable Trust for the benefit of Milton A. Barlow Jr. So I'll just use Allen as shorthand to refer to my client, the appellant. I'll also refer to Austin Trust Company, the trustee of the trust, as ATC. And ATC took title to the property for an interim period on Allen's behalf. I'll use the term interim agent in this argument to refer to a party being analyzed as a potential nominal grantee. And I'll also use the term applicant as the party seeking exemption. So this appeal requires the court to address a question of first impression. And that question is, can a trustee with broad contingent fiduciary powers act as a nominal grantee under the naked title regulation? That's what I call the 9 DCMR 509.1. And the answer is yes. A trustee with broad contingent fiduciary powers can act as a nominal grantee under the NTR. And the answer is found directly in the language of the NTR. And what I first want to emphasize is that the NTR it's an example of a supplemental deed, but it is a special example of a supplemental deed. It's not a traditional example.
Mr. Davidson, I hate to interrupt you. You started to tell us that something could be found in the language directly. And then you sort of swerved off to a more general conversation. Could you go back and tell us what that specific language is that answers the question here for us?
And just before you answer, can we start the clock as well? Sean, thank you.
Certainly, the NTR provides a tax exemption for Allen when the grantee on a recorded deed acted as a nominal grantee for the sole purpose of holding on behalf of another person naked title to the property described in the deed. The critical language here is that the other person has to be different from the interim agent. One person acts on another person's behalf. Those parties have to be distinct. They cannot be identical. And that's what makes this a special use case for the supplemental deed. It's a non-intuitive type of supplemental deed created specifically by that regulation, where the parties are actually distinct and not identical. And that's what's critical about the briefing to date, is that the analysis has actually been wrong. And the analysis in Columbia Realty and Cowan also did not analyze to see if the parties were distinct. Instead, there was a requirement that the parties be identical. The reason why Cowan and Columbia Realty use a different analysis is because the supplemental deed statute, which simply defines a supplemental deed as one that confirms, corrects, modifies, or supplements, that is the broad situation. The narrow special case situation is the NTR. The NTR was not addressed under Columbia Realty or Cowan. The NTR was mentioned in dicta in Columbia Realty in a footnote. The NTR language, the predecessor language of the NTR, was quoted in a footnote in Columbia Realty, but it was only mentioned as a potential analogy to the facts of that case. It was not There was no NTR analysis done under Columbia Realty.
Mr. Davidson, is this the argument you made in your brief to us?
It is not. It is the argument that was designed to be made in the reply brief.
Yeah, we generally don't accept new arguments in the reply brief or at oral argument. So should we? I mean, I don't know if you want to stick with it, but generally the way we treat arguments and replies and oral arguments, not always. Sometimes they could give us enough pause to ask for supplemental briefing, but usually we say that's too late. Stick to your argument in your appellant's brief. Now, this is your time, so I'll let you choose how you want to do it. But you're in somewhat treacherous territory in the sense that it's a very easy argument for us to ignore on the basis that you didn't raise it in your opening brief.
Understood, Your Honors. The critical fact, the critical issues with this argument is that it's the law has been in front of us the whole time. It really wasn't an argument that I noticed until writing the reply brief, but then it just became so clear while there was so much discrepancy between what Cowan and Columbia Realty were saying and the situation at bar, and why the analysis was fundamentally opposite in those cases as what is in the exact language of the NTR. The NTR requires a completely different analysis from Cowan and Columbia Realty, and no one really figured that out. And even in the Superior Court below, the judge didn't see that the NTR is a special case, that Columbia Realty and Cowan just.
Well, are you trying to say, Mr. Davidson, that it's a purely legal question that, you know, we need some hook for you're telling us that no one saw it, and we're a court of appeals. We appeal, you know, we review rulings on things that were raised below and arguments that were made and in a way that the government could respond to it. I mean, what's your hook here for why we can consider this? It's purely legal and the government is not prejudiced. We don't even, you know, they didn't even have a chance to respond to it.
I think the issue is that to allow Columbia Realty and Cowan to dominate the rationale in this case is so fundamentally wrong. It is so diametrically opposed to the analysis that needs to happen that it would really fly in the face of justice and expedience in the future in addressing cases like this if the court did not consider that the analysis all across the board should be revisited. Clearly, this is an issue that has come up for me very recently, but the concern is it's a critical concern because the analysis is that the parties have to be, the analysis starts with a distinction that the parties have to be distinct to fall into the NTR.
I'm sorry, because I'm just totally lost by this argument. So to fall under the what?
The naked title.
You keep saying NTR. What's the NTR?
The naked title regulation.
Naked title regulation. Okay. So you're pointing me to 509.1.
Yes. Yes.
Okay.
That requires distinct parties. That requires an analysis based on the acts of the nominal grantee toward the property. The key word is act, not how how an interim agent could have acted, should have acted, contingencies about the action. The key is the analysis has to be done on the actual acts of the party. And
well, in this case, Mr. Davidson, the actual act of the party was to create a circumstance. He had an option, did he not?
He had an option. He could
have taken the money. The trust was prepared to give him the money, which the trust had the right to do, correct?
The trust had the right to do.
And they could do anything. This was an irrevocable trust. They had all the power to manage that asset, the assets in that trust as they wished, right?
Yes, the trust.
And he declined that offer or chose to ask them instead to purchase the property themselves in the trust. And then the trust obviously paid the recordation fees, and other transfer taxes, correct?
He directed the trust to pay those fees.
So in essence, he directed the trust to purchase the property, meaning that the property had to eventually be transferred to him if the trust was ever dissolved, as it was in this case, or to his heirs, I assume, under some other document, if he were to pass, correct?
He made all of the decisions concerning the
And
property.
and the recordation of taxes came out of an estate that was actually in a trust that was actually set up for more than just him, correct? It had contingency beneficiaries or secondary beneficiaries, correct?
It had contingent beneficiaries, but the trust made the decision to become a nominal grantee with respect
Where
to.
is that? When did they make that decision? Just
They made-
because they agreed with him to purchase the property, that is in fact a decision to become a naked, an NCR?
They agreed to purchase the property at his request. They excluded it from calculations of the management fee so that they did not charge him fees to manage the property. They allowed him to have exclusive use, benefit, and control of the property. They did not question.
Keep saying they allowed him. Is there something in a trust that's inherent in the trust that requires them to take on those duties if they purchase property? Such that we can read into their allowing him to do something as being indicative of the trust taking actions that are inconsistent with its other legal obligations?
The acts of the trust took were not inconsistent with its other legal obligations. The trust had the ability to determine that it was going to act nominally with respect to this property, that it was going to carve out this property for its beneficiary for his exclusive use and control, for his exclusive ownership, and to allow him to take have all of the management ability, ownership, possession, all the control of the property, not to include it in their management fee, not to ask him about renovations.
Well, they wouldn't have a management fee if they weren't managing the property. Right?
That's absolutely right. And that's why.
And so the fact that he's going to live there in the home they purchase, I'm asking you, is that some sort of obligation the trust has? Even if people live in property, they have to manage it such that they are making an affirmative statement by not managing it? Your argument is that this made it sort of special, that they did not manage or charge a management fee. And I'm trying to understand, was there any obligation on the part of the trust to charge a management fee such that we can read their failure to charge a management fee as somehow evidence that supports your contention that they were just an NCR?
Yes, the trust was designated to handle the trust corpus on behalf of Mr. Barlow. They were designed to. They had full management authority of the corpus. They had full discretionary authority of the trust corpus, subject to the intent of the grantor, who made very clear in his precatory language to the trustee that he wanted this property to be for the use of Allen whenever he needed it. But yes, the trust had discretion to make decisions about the property, and there were contingent beneficiaries that, you know, if needs arose, theoretically they could have addressed those needs. But that the
Well,
trust.
can you clarify something about the secondary beneficiaries? Are they just completely out of the picture as to this trust, or is the trustee making distributions and payments to them sometimes as well as the primary beneficiary?
They're completely out of the picture. During the period that ATC held the property, during the entire period, there were no payments to anybody else.
What about outside the context of the property? Like,
None,
okay.
none.
They're just there in case he dies.
Pretty much, yes. They're in case he dies.
Can you just enlighten me as to why it is you think your client then in 2007 had the trust buy the property instead of handing him the money? I'm sure, I mean, this will be a question for the district as well. They might have some theories, but what's the explanation for that?
My client was going on travel, international travel. He was concerned about his well-being because he was doing reporting in far off areas of the world that were dangerous. He didn't want to have anything happen to him and have the property in his name. He wanted to keep it in the trust while he continued these activities that were dangerous.
But he could have purchased it himself and then put it into the trust.
He could have,
Correct?
he
Yeah.
could have, but he asked the trust to hold it as a nominal grantee until he returned from his travels, or until he decided to actually take ownership of the property. And that's what the trust did. The trust held it for his benefit and solely for his benefit, carved out a method of ownership where ATC, the trust company, owned the property, didn't ask him for any information about the property, didn't make didn't find out about renovations, which would be needed to compute the tax basis if the trustee wanted to keep information on the property for purposes of valuing it and filing accountings for it. So the idea was that the trustee carved out, the trustee carved out this property for Alan Barlow's exclusive use. And the trust is distinct from Alan Barlow, which is required by the NTR. And it makes sense that trusts would be nominal grantees. They're the optimal vehicle for a nominal grantee because they're the only party that's legally designed, that's legally created to hold property on behalf of another.
Mr. Davidson, you have about a minute. Is there any part of the argument that you made to us in your brief that you want to reiterate here or support here through your argument? Since we obviously don't know what to ask you
Okay.
about your
right.
original argument at this point.
So the 14-year period that the trust had, the NTR has no time restrictions. The NTR requires action, and the language of the NTR requires action over contingencies. That's how the evaluation is done under the NTR. The crux of the argument here is that the evaluation has to be done on action of the interim agent towards the property. The analysis has to be based on action and not contingencies. The Superior Court only considered contingencies. There are contingencies that apply in Alan's favor, but the contingencies relate to the fact that Alan could have been a trustee on his 21st birthday, could have been a trustee for 61 years. That the grantor sent the precatory language in a letter of intent stating that he wanted Alan to have free use of the trust capital at an age of genuine maturity. So, there are contingency type issues that go in Alan's favor as well, but the key is the actions. The actions of the interim agent, ATC, were not evaluated.
But again, when you say the Superior Court only considered the contingencies and not the action, you didn't ask the court to consider action.
We filed an affidavit listing out all of the reasons why the trustee abdicated his powers as trustee and became solely a nominal grantee. And that affidavit was filed as part of the record, and it listed out all of these issues about the 2007 deed and the way it was titled, the fact that Mr. Barlow invested $1 million in the property, the fact that no management fees were taken by the trustee at any point, during that interim period, that 14-year period where the trustee had control of the asset. We talked about how in the affidavit, how Mr. Barlow exercised exclusive and total control over the property. And
But
Yeah.
your argument, and I'm sorry if I have this wrong, but just is that the Superior Court judge should have inferred the parameters of the legal argument that you're now making.
the
You're saying
Superior
you
Court-
gave him the facts.
They were all in an affidavit in support of summary judgment. They were disregarded. They were all not, they were all disregarded in favor of the contingency powers of the trustee. For the Superior Court, the contingency powers were dispositive. And the Superior Court did not consider all of the facts that supported action of the interim grantee, the interim agent toward the property. None of those were considered at any point in the Superior Court opinion.
Can I ask a factual question? Let's say your client, Alan, passed before dissolution of the trust. Would that property, do you think, go to Alan's personally named heirs? Would it go through his probate process? Could he name who would inherit it through a will? Or do you think it would have to be disposed of by the trust?
It would be disposed of by the trust. But that would be the case with any trust. I mean, trusts are used.
Do you think that's the case anytime somebody holds naked title as grantee for somebody else? I mean, you would think there would be some document that sort of denotes, you know, really, we're just a vessel here. And if this person passes, this property will go to their heirs. I mean, that is a significant legal consequence of the trust holding this property that is quite different than how I would think a naked title grantee would operate. I would think they would have to pass it on to that individual, and their heirs and whoever they named in the will would get the property, as opposed to the secondary beneficiaries, which is what's going to happen in this case. But you don't think so?
Well, the terms of the trust control, if the person seeking the application passes away. But in this case, you know, the person seeking the application is alive. And what's dominant is the actions toward the trust, towards the property by the interim agent during that period, that 14-year period of ownership. Contingencies outside of that are going to be less important than the actual acts during the period that the interim agent holds the property. That's what's going to dominate the analysis on whether it's a nominal grantee. What happens in contingent situations is not going to dominate. The language of the NTR doesn't discuss contingencies. It discusses actions while the interim agent has the property.
Okay, thank you, Mr. Davidson. We will give you some time for rebuttal.
Thank you.
We'll hear from the district.
Good morning. May it please the court, Tylen Trayer on behalf of the district. I'd like to begin with the forfeiture point that you mentioned, Judge Deal. I think a lot of what we've heard today is a new argument that was not advanced in my friend's brief or before the Superior Court. And I think what I heard just now is an argument that the nominal grantee regulation must apply because the trust is a different legal entity from Barlow, the natural person. And so, first of all, that is a new argument. But second of all, it's also exactly the opposite of what Barlow has argued all along. I believe his argument all along has been that these are, in fact, should be considered the same entities because there are interests on both sides of the transaction. And of course, that original theory has been soundly rejected by this court several times in the Columbia Realty Venture line of cases. But it simply cannot be the case that the nominal grantee regulation simply turns on there being two different legal entities here. The regulation is a very narrow carve out from the supplemental deed exemption and allows for the possibility that there might be a sort of straw entity that performs a very ministerial act, existing solely for the purpose under the language of the regulation of holding naked title to property on behalf of another person. I think there's a very very limited universe of transactions.
Can you illustrate one for me?
Yes, as we discussed in our brief, reverse like-kind exchanges under the federal tax code is one example, as was discussed in this court's Vornado case. So there you have an exchange accommodation title holder whose exact purpose is to act as a vessel where title is parked for a very time-limited period in order to accomplish a transaction and derive certain tax benefits. Under the terms of that arrangement. But I think, the fact that there are, a limited set of circumstances where, a transaction might qualify under the nominal deed, under the nominal grantee regulation is not a reason to try to construe the regulation more broadly. The regulation is quite clear that, again, it has at least, as I read it, 3 requirements. There has to be a nominal grantee, in other words, a grantee in name only. That grantee has to serve as, function as having the sole purpose of holding naked title on behalf of a specific person. And so I heard my friend say several times that he believes affirmative acts are dispositive here, but I don't think that's the right way to read the regulation at all. Act as a nominal grantee here is most naturally read to mean that we're looking at the role that the entity served here. Again, how did the entity function? And it simply can't be the case that in undertaking this inquiry, we would simply, throw out the window the trust agreement, the very instrument that creates the trust and imbues it with all of its authority. And I heard my friend, of course, acknowledge that the trust agreement gives to the trust acting through the trustee very, quote, broad powers, of course, independent fiduciary obligations, and those were carried out on behalf of all of the beneficiaries of the trust. And I would dispute one characterization that my friend made about the secondary beneficiaries to this trust. I think the trust agreement is very clear that they're not just, I think as he said, completely out of the picture. They are, meaningful secondary beneficiaries. And the trust agreement says it's at section 2B in particular that the trustee can pay income or even principal to any individual within this group of beneficiaries or any group within the larger group of including both
Is
the
it
primary.
clear that that includes like while the primary beneficiary is still alive? And do we know whether such payments were made?
Yes, I think the plain language of the trust agreement establishes that, yes, it does apply even where the primary beneficiary, is still alive. And moreover, I think that much is clear too, as the Superior Court explained by the fact that in the proceedings in the Texas Probate Court to terminate the trust, in fact, the secondary beneficiaries needed to participate in that process. And of course, they ultimately waived their interest, but their participation was legally required.
I understand the district's sort of formalistic position that in 2007, the trust took possession of this property. It's a distinct legal entity. Look at Cohen and Columbia Ventures and distinct entities. That's all clear enough. So that's a perfectly good position that has a fair bit of precedential support. And I appreciate that in tax law, formalism is often reigns supreme. But from sort of a practical level or a functional level, can you tell me, let's say we had a rule that said, where a person has just sort of clumsily organized their affairs and has benefited in no way through a bad decision to funnel this through a trust. I guess what I'm asking is, in 2007, is there a reason that you can think of why it would have benefited Mr. Allen Barlow, to have the trust hold this property in a way that it would now be unfair for him to sort of claw back to have his cake and eat it too? Well, I got this benefit, but now I don't want to deal with the consequences of having to pay another recordation tax.
Yes, and mean, I don't want to speculate too much. I'm not privy to, all of the details here of the financial transaction, but I imagine instead of taking a distribution, there would be, a gains tax on that, I believe. And, putting the property, the residential property within the trust property, I mean, the property grows in value, all of those years as well. And I think, Judge Washington, to return to a point that you made, taking a step back here, this is a legal question that does arise in the context of appellant making a considered choice to forego a distribution, and instead the property was purchased within the confines of the trust and subject to the terms of the trust agreement here. And this court in Columbia Realty Venture noted that in rejecting that attempt to take advantage of the supplemental deed statute there, that where parties structure their business affairs in a certain way, we hold them to that choice. And the court made quite clear in that case that the parties then must operate consistently and not seek treatment that would better suit their interests in a particular setting. And that reasoning holds equally true here.
I'm not totally sure I understood the answer to my question. I mean, the fact that the property, gains value, that would be true regardless of whether or not the trust held it or he held it. I think your answer is, one, it would have been a taxable distribution in 2007, and so that would be one reason why Alan wanted to avoid it. And then I think you also offered a capital gains argument that I'm not quite sure I understood. So can you help me out with both of those again?
So again, I can't speculate too much, but I do think.
Sure, I'm just kind of guessing,
right.
give me theoretically why,
Theoretically why, I think because at the very least, there would have been tax liability on the distribution at the time. And so, but I think to your larger point about, whether this was, a clumsily organized decision, versus, someone making a very deliberate choice. I think we have to assume here that yes, a deliberate choice was made. And actually, the type of characterization of what occurred here that my friend is urging for, it's actually, as a general matter, as OTR concluded in its rejection letter, as a general matter, trusts can't operate as the type of completely, bare, passive trust that my friend urges for. That is actually not recognized under the law of Texas or the district for that matter. So it can't be the case, as my friend argues, that their intent should govern, that their intent can somehow create the type of trust that actually doesn't exist under the law that he believes then would entitle him to a benefit under this regulation.
So is there a distinction drawn there between an irrevocable trust and a revocable trust when it comes to that sort of an analysis? The fact that this was an irrevocable trust with all of the authority and power vested in the trustee, not in the owner of the assets, that is what makes this different and makes this a trust, as opposed to if the trust had been a revocable naked trust that I created for the purposes of sticking something in there for a short period of time that I can totally control. Is that a way of looking at it?
Well, I'm not even sure a revocable trust could exist in that way. Again, is simply a place to hold property. I think in that instance, by operation of law, the title actually collapses and vests through to the beneficiary. But I think your point is a significant one, that irrevocable and revocable trusts are treated very differently under the district's tax laws. And again, keeping in mind here as well, the background principle that this exemption is, the burden is on Barlow to show that he's entitled to an exemption. But there are a host of exemptions that are applicable to irrevocable trusts. I think those came into law around 1991, specifically because the legislature considered that the cost of those transactions were too high, and they wanted to promote that as an estate planning option available to folks. But it did not extend that same exemption to irrevocable trusts. Sorry if I misspoke. That was applicable only to revocable trusts. And so the legislature made a choice there to only extend that benefit to a different type of trust. And as this court, I believe it was in Columbia Realty Venture as well, said that it's not the place of this court to go looking for additional exemptions that are not provided for in the law. Indeed, that would run exactly contrary to the principle that we construe exemptions very narrowly against the claiming party.
Can I ask, When you say this, trust can't operate this way, and it doesn't exist under law, is there something that's sort of, uh, intuitively bad or nefarious about that happening? And I think maybe your opponent gave some examples of other states creating such a thing. Is it just that it's fine, you could do that, but we didn't do that? Or is there something bad about that?
He hasn't referred to those trusts on appeal, just to be clear. That was an argument that was made below that he hasn't raised. So I think any reliance on those types of passive trusts has been forfeited, but he did refer to a few jurisdictions where it's my understanding, in a few jurisdictions, that type of passive trust is called a trust under those laws, but we would, under the laws of the district, understand it to be more of a principal agent agreement. And I think this is getting kind of far afield of the briefing, but I think this all goes back to a common law, the statute of uses, which was a common law way of actually preventing exactly what this case implicates here. Folks creating, a device under the law in order to avoid certain liabilities. So the district's law and Texas law, which governed at the time here, very much is consistent with those original purposes.
You made that, your comment again, trying to get around or create favorable circumstances, tax-wise or others. And so I'm going back to my colleague, Judge Deal's question, and piggybacking a little bit on that and a little bit on my colleague, Judge Beckwith's question. In this particular case, the recordation taxes, for example, and the transfer taxes for this property were paid by the trust. Was is at that time, was that before or after? Well, I guess it had to have been before. So the question is, those assets that were used to pay those, were those assets that could have been used by the secondary trustees if they had asked for, excuse me, money such that there was some diminution of value of the trust without seeking the secondary trustees' permission?
So first of all, I think one of the taxes was paid by what would have been, like a winding up of the trust, and the other would have been paid by Mr. Barlow.
Okay.
But I think this did occur after the trust had been terminated as part of a wind up process. But Your Honor is correct that that money, if you trace it back, all originated from the trust corpus, which was originally established by the grantor, again, to the benefit of all of the secondary beneficiaries to the trust. And, at bottom, the trust is a fiduciary relationship, really. I don't hear any dispute from my friend on the other side that the trustee here had a number of duties and responsibilities far beyond, the sole purpose of holding naked legal title. The trustee was empowered to manage, invest, reinvest all of the trust property, and with respect to real property in particular, was empowered to act as if the absolute owner thereof. And that's a very far cry from serving as a nominal grantee.
So the trust he could have sold this property if it thought that the property values or the investment wasn't a good investment for the trust, or there were better investments.
That's correct. And exercising its independent, fiduciary, obligations and judgment. So if there are no further questions, we would ask that this court affirm. Thank you.
Thank you very much. Mr. Davidson, we'll give you 3 minutes on rebuttal.
Thank you. I wanted to really get into the like-kind exchange, the reverse like-kind exchange example cited by my opposing counsel in her brief as an example of a exempt nominal grantee transaction. And I think that example really speaks to what the problems are with that argument. And the like-kind exchange, first of all, trusts are often used in 1031 exchanges. So here you have a trust acting as a nominal grantee in a 1031 exchange. The exchange has to be evaluated by the acts of the interim agent as far as whether the tax laws are complied with. So you have an evaluation of actions, just as you should in this case. You would have an evaluations of actions in the 1031 case. It's a tax exempt situation. again, this is a trust that does a 1031 exchange is going to have contingent interest, contingencies that it's going to have to be able to handle. It's going to have some management authority. It's going to have something that's going to be done if the applicant dies during the 1031 exchange. The trust is going to have to handle that contingency. Yet and still, it's viewed as a nominal grantee. So I think that use case undermines a lot of the argument that one, that a trust can't be a nominal grantee. Two, that the actions are dominant in the analysis. The actions of the interim agent toward the property are dominant, not contingencies. And three, that this is a situation where it can be tax exempt, and the analogy is pretty clear. I mean, I feel that if the Superior Court's decision were to hold, it would fly in the face of the bare language of the NTR, which states that the actions have to be the dominant criterion and that the parties have to be distinct and not identical. And the reason why the trust is often argued in the Columbia Realty line of cases, the trust is not going to be an appropriate vehicle for a supplemental deed exemption, is because in that case, the parties have to be identical.
One thing that opposing counsel said is, the trust could always have sold this property. Let's say the trustee, they purchased this property in 2007, is very savvy and is noticing the mortgage systems collapse and can predict there's going to be a huge drop in value in this property. It's time to get out. This is going to be bad for the trust. Let's sell it. Do you disagree that the trust had that authority?
I agree that the trust had that authority. However,
so why does that not take it out of the plain terms of 509.1 that says its sole purpose is for holding it?
Because
it has the authority to sell.
The authority is not dispositive. It's not dominant. And when you look at the language of the NTR, it's not the authority to do something, it's what they actually do. And
if something's sole purpose is to hold it, then it shouldn't have any ability. If the only purpose of an entity is to hold a property, then the ability to, and really the fiduciary requirement to make sure you're making fiscally responsible choices with whether or not to hold or sell, no longer do you look like a vehicle that sole purpose is to hold that, but to make responsible financial choices with it. I mean, it looks wildly different.
Every interim agent is going to have rights and abilities to do things that they're not going to necessarily.
You think in a reverse like kind exchange, a holding company that is set up to hold a property for, I forget if it's 90 days or 6 months to find a like property that you can do the exchange with. You think one of those agents has the authority to sell the property on its own if it wants to?
Well, what if the applicant dies? What if the applicant dies during the 1031?
I mean, I don't know what happens if the applicant dies, but here that has nothing to do with it. Here, the trustee could sell it if it thought it was the fiscally responsible thing to do.
Right. So, and the distinction is between could and did. Under the language of the NTR, it is the action that dominates. And there has to be an analysis of what happened during the time that interim agent held the property and what it did toward the property. Certainly, it could have done a lot. There's no question that there were contingent benefits there. On the other hand, there's no question that the grantor wanted Allen to have sole use of the corpus of that trust after maturity. I mean, that's written in his letter of intent. So there are contingencies and powers that go both ways. And there always will be. There always will be contingencies that, may or may not get considered with a lot of these, especially when trusts are involved. But the key is what actually happens. The key is, does the interim agent or the trust act to set itself up for a particular transaction as a nominal grantee with respect to a particular property?
And the Office of Tax and Revenue is supposed to make that determination in each individual case after a review of everything the trustee may or may not have done, and then make its tax determination, as opposed to basing it on the actual transfer of the property deed to another entity. So your argument would be that in any and every circumstance, in which there is a trust like this one set up and it's holding property and not charging management fees and not not selling it or not doing anything to it at the end because it wasn't necessary, then the question becomes, what did they do? And the tax consequences flow directly from an evaluation of how active the trustee was.
Yes, yes,
Okay.
the applicant has the right to make the argument that in this case, the interim agent acted as a nominal grantee. It doesn't happen often, but certainly they should have the right in particular cases to make that argument. Otherwise, really the purpose of the NTR is really in question. I mean, the government struggled to find a use case for the nominal grantee exemption. And the one it brings up, the reverse like-kind exchange, is actually very similar to this case. It involves a trust. It is evaluated on actions. Contingencies don't fall into the analysis. And if you're going to have a law like this on the books, if it's going to have any meaning at all, then there has to be a way to analyze the law, and it can't just be categorically dismissed and where there's really no use case that can be cited that makes sense. I mean,
Are you talking about a statute or a regulation?
I'm talking about the NTR, the naked title regulation 509.1. It has to have a purpose to allow some flexibility in transactions where an applicant can explain to OTR, hey, look, this is a nominal grantee transaction based on these facts. And OTR can't just categorically deny on the basis of, oh, no, we'll use the trust. That's not, that is completely, there's no language in the NTR that forbids the use of a trust. And in fact, a trust is probably the best vehicle possible to use for a nominal grantee agent, because it is the only legal construction where a party is required to hold an asset for the benefit of another. And so it's a perfect vehicle for it. And under certain situations, an applicant should be able to apply to OTR and say, hey, look, in this situation, our trust did the following things that give it the eligibility for the nominal grantee exemption. That should be allowed. And if it's not allowed, then the court really has to ask, what is the purpose of the nominal grantee exemption? Does it have any meaning at all? Does it have any weight at all? Are we going to completely preclude the ability of parties to fashion situations that meet the nominal grantee standard that fairly should be analyzed through actions of the interim agent and deserve the chance to go before an OTR and have that evaluation? OTR did not give Alan any type of factual evaluation.
Thank you very much, Mr. Davidson. I think we understand your argument. We will take the case under advisement. Thank you.
Thank you.
The next argument, the next case on this morning's calendar is number 24 CV 426, YOSHIE Davison versus American Psychiatric Association et al.
May I proceed?
Yes.
Good morning. May it please the court. My name is David Branch. I represent the appellant YOSHIE Davison. This is an appeal from a grant of summary judgment by the Superior Court. In granting summary judgment, the trial court resolved factual issues that are reserved for the jury. And there are two particular factual issues that were resolved by the trial court that should have been reserved for the jury. There are two legal claims filed in this matter. One is under the FMLA, Family and Medical Leave Act. The other is under the DC Human Rights Act. For the claim under the Family and Medical Leave Act, there was a jury question on first whether Ms. Davison resigned from her position. There was some dispute in the record as to whether she resigned. The record indicates that on February 15th, 2022, there was a meeting regarding her performance evaluation. During the course of the meeting, I'll get into some of the other details, but as it relates to the question of whether she actually resigned, there was a question of whether she resigned because she was told by Dr. Levin that she could get with Mr. McFadden and discuss severance if there was going to be some consideration of her resigning. But Ms. Davison did not resign. There was no final confirmation that she was going to resign. So that's one factual issue that should have been reserved for the jury. And that leads into the more important factual issue, and that's whether anyone discussed with Ms. Davison whether anyone discussed with Dr. Levin, Ms. Davison's request to be placed on FMLA leave. She definitely applied for FMLA leave on February the 18th, 2022 in the morning. And later that day, Dr. Levinson responded and said that I'm accepting your resignation or your termination.
Yeah, but I'm sorry, go ahead.
Well, I mean, I was going to start with the second point, which is, it sounds like you're talking, when you say there's a genuine issue of fact, usually what I take you to mean is I could look at the evidence and I could say either way. There's some evidence that he was told and there's some evidence that he wasn't. What is the evidence that he was told that she had asked for FMLA leave?
Your Honor, the evidence is when he was asked at his deposition, his response was, I can't remember, I don't recall.
That doesn't really sound like evidence that he was told.
But
Is there somebody who says, yes, that I did, yes, that would have been the normal process? Is there anything like that?
we don't have anyone who specifically said that they told him, but the court reached the opposite conclusion. The court concluded that he had not been told, when in fact he stated on the record, it's his deposition, I don't recall, I can't remember.
Well, I mean, so that could be a misstep. Maybe more precisely, the answer is no jury could find on these facts that Ms. Davison has carried her burden to produce evidence that he had been told. But that seems like an inconsequential misstep if it was just something that the trial court misstated.
Your Honor, I think that goes to credibility, and that's something that can't be resolved by the trial court. If a jury hears all the testimony, particularly the sequence of events, she applies for FMLA leave at, say, 8:40 a.m. She has 600 hours of leave, which is 15 weeks of annual leave that she could use for FMLA leave. After hours, at the end of the workday, this was heading into a holiday weekend, but after hours that evening, 5:40 p.m., she gets an email from Dr. Levin saying, I'm accepting your resignation. When you factor in all those factors and the fact that when he specifically questioned on whether anyone discussed with him, whether
they could take his denial,
discuss her FMLA request, he says, I don't recall, I don't remember.
So I think I might agree with you on many records. The timing itself and the denial could lead a reasonable jury to think, well, really what's happening here is sort of retaliation. It seems hard to draw that conclusion on this record, given the pretty obvious alternative explanation that this is close on the heels of a meeting where I believe it's undisputed that your client says, my last day can be, I can resign as of March 4th, or if you want me to stick around for this big upcoming, I forget what it is, conference coming up in 2 weeks after, if you want to give me some severance package, I can stick around the extra 2 weeks for that. So I appreciate your point that, well, that hadn't been finalized, so that's not a formal resignation, but just, am I correct that it's undisputed that that was the exchange on February 15th?
Your Honor, I think that's probably a pretty good summation of what happened at this meeting, but this was during a meeting where there was a heated discussion where, she was told that her job was to serve him and,
Sure, he might be a jerk. I don't know. That could be a perfectly good explanation, but the problem is, people can sometimes fire people for even if it's because they're jerks. The question is, was he retaliating against her when it seems even if she hadn't resigned formally on February 15th, it sure seems to have been the impetus, her statements and that meeting for her termination, which would not give rise to a retaliation claim.
Well,
There's just such a big elephant in the room, such an obvious reason why her termination would have happened independent of any request for FMLA leave. In fact, it sure looks like she's taking FMLA leave because of her imminent termination.
no, Your Honor, actually, if you actually look at the performance evaluation, there was no issue with her meeting the metrics for her position. And I think the record includes the statement that there were no plans to terminate her employment.
I'm sorry, because of the imminent end of her job voluntarily. That she has said, I'm out either on March 4th or on March 18th. You guys will figure it out. We'll figure out what kind of severance you want to pay me, but I'm out. And that is what precedes her request for FMLA leave.
But Your Honor, there were a number of contingencies. One was the instructions to her to meet with Mr. McFadden to discuss severance. You would have to come to some type of agreement, assuming if they were not able to come to some type of agreement on their severance, that would not necessarily mean that she was ending her employment. But still, under the FMLA, if she submits an application for FMLA, regardless of what the company's process is, and this can't be, a race to the courthouse or a race to the CEO to give notice to the CEO about her request for FMLA leave. The fact that she requested FMLA leave, it should have triggered the protection under the FMLA, and anything that followed that, including her termination or some other action, would constitute interference or constitute retaliation. So the APA was placed on notice of her request for FMLA leave through Human Resources. That should have been imputed to the senior managers or senior officials.
I thought that's where you were going. Can you tell us what case you rely on for the imputation theory? Because that has to be it, since you have no evidence. And I understand and appreciate this argument that if a jury is presented with this timeline, your argument is that's evidence if they decide that he's incredible, that in fact she was retaliated against. That's your argument, correct?
Yes.
But the problem is with that we have cases that suggest there has to be more than imputation of knowledge to the person who makes the decision. And the question then is, well, what case do you rely on for that proposition? Because I'm not finding it. And to your argument, that would be very helpful, would it not?
Your Honor, and I'm kicking myself. I thought about that as I was, preparing, because I actually appealed a case to the Court of Appeals. I think it was an unpublished decision by the Court of Appeals, where the court essentially found that the plaintiff or the appellant's reporting to Human Resources could be imputed to senior officials. This was a claim against.
If it was part of their normal process. Yes, if they had a process and there was time and she had made a request and the process was that this request is typically done in this particular way, it's given to them, they inform immediately the supervisor. The supervisor gets has to respond within a certain number of, yes. And that's why I think Judge Deal's question was important. Here I see nothing in the record where there's any evidence that would have helped you survive summary judgment, that was a practice or of the company, such that we could impute that information to the person who made the decision, which nobody seems to dispute in this case, was one individual. So I guess but you don't have a case. You don't have a case from any jurisdiction necessarily that that says what you are arguing here now. That is, if I make a filing, if I file for family medical leave, at any moment after that, if I am terminated, it's retaliation, regardless of who terminates me and for what reasons.
Your Honor,
Enough to survive summary judgment, not ultimately.
I don't have a case, Your Honor, but the process that's set up by the employer, where the employee is given a point of contact to file an FMLA claim. And then there's a period of time, this is in the record, where the employee is permitted to supplement the record with certification from the doctor. But that's all that's required of this employee. We took the deposition of Miss Oliphant, and I think she described the process. She was the HR person that the contact was made to. But the complaint, the request for FMLA leave comes to her, and then it's filtered through whatever.
Ms. Oliphant's the one who says, I never told anyone about the request, right?
But there are other people who are copied on the emails. There are a couple of emails.
And were they questioned as to whether they had made any communication or had any contact or with the ultimate decision maker?
Yes, they were. Well, one person was Mr. McFadden, and he was questioned. I think we submitted a supplemental his deposition transcript as well.
Just to clarify these facts, the appellee's brief says Dr. Levin's undisputed testimony is that he had no knowledge of Ms. Davison's communications with Ms. Oliphant or her FMLA inquiry when he sent the email accepting, March 4th as her resignation date. Do you agree with that that's undisputed testimony?
Concerning Ms. Oliphant?
Yes.
Yes. That is his testimony, but when he was specifically questioned about whether anyone informed him that Ms. Davison had requested or submitted an FMLA application, his response was, I don't remember, I don't recall.
Isn't this an umbrella? Like it says that he had no knowledge of Ms. Davidson's communications with Ms. Oliphant. And you're just saying that, wouldn't that cover someone else telling him about her communications with Ms. Oliphant?
No, Your Honor. I mean, if he had no communication whatsoever with anyone about Ms. Davison's FMLA request, he could have just said that. I didn't talk to anyone. That would be simple. No one told me.
He said he had no knowledge of it, of her communications.
But at his deposition, he was questioned on whether anyone informed him or if he knew about her FMLA request. And his response was, I don't remember, I can't recall. But he could have very easily just said that, unequivocally, no one told me anything about her FMLA request. That would have been the end of the matter. And Your Honor, so I'd like to actually go on to the discrimination claim as well. So 2 claims under the DC Human Rights Act, one for sex discrimination, one for race discrimination. If you view all the evidence in its totality, it supports, I don't want to use the word direct evidence loosely, but it's very close to direct evidence. We have a supervisor referring to her as honey and not on my watch, honey. She's being ordered to pick up donuts. She's a professional level chief of staff employee. Part of her job requires her to pick up donuts when there are meetings and go pick up meals as well.
We have a monthly all judges meeting where the junior judge is in charge of bringing coffee and pastries.
I hope you're not.
Not the junior judge. I mean, I don't know. I get it. That's if you had a lot of incidents like that, it might add up to something. It doesn't, I mean, there are all sorts of petty indignities with even high level positions. So it's not doing that much for me.
I'm looking at this in the totality of the circumstances. In addition, there was a discussion or his refusal to acknowledge that an Asian female was in a protected class. Extra assignments given to her with no stipend, while assignments given to white male employees receive stipends. And finally, this performance evaluation meeting.
So, sometimes they did, right? There were a couple other comparators who had taken over the interim head of HR position who did not receive any stipend. Do I have that right?
I don't specifically recall that. I know that she was given the interim HR, but other assignments as well. And these were usually paid assignments when and people were given stipends when they had to carry their duties. She was the chief of staff, plus these additional.
But under the law, how do we look at that? I'm trying to figure this out. I understand it's a title. You keep saying chief of staff, she's high level. But her duties as chief of staff, when somebody wants coffee and donuts, for example, let's just use that since you use that. Certainly him asking her to bring coffee and donuts, if there are people below her as a chief of staff to whom she can make that assignment, is there a reason why we should look at the fact that he asked her, his chief of staff, the person who is most responsible to him, to bring something in as therefore discriminatory? I mean, just because he asked the person who is next in line to him, his chief person, because that seems kind of, I mean, certainly if she had someone who worked for her and she said, bring in donuts, he wants donuts, and coffee, would that have been discriminatory because that person was a female?
Your Honor, what I would say is, first, this is totally out beyond or outside the scope of her responsibilities, but also it's not something that happened infrequently. This is something that on a regular basis, but this paints the broader picture of how he saw Ms. Davison as an employee, which culminated in this meeting where he says, "You are here to serve me." This is a white male saying to an Asian female.
I understand that. She is his chief of staff.
Yes.
What is she there? I mean, I understand, and I'm not, again, I understand how you can interpret how it can be interpreted that way. But my chief of staff comes to me and I ask them to do something. They say, I'm not here to serve you. I'm wondering why this person is my chief of staff.
Well, Your Honor, it's one thing if the employee says, I'm not here to serve you, but if it's totally different, if you're saying, as
What's the difference?
the judge, your job is to serve me. Your Honor, I
don't quite understand the difference, except it goes to sort of this environmental question you keep arguing about hostile environment. I can see it as part and parcel of a hostile environment of perhaps because you're taking the totality of the circumstances and saying, hun and honey, and you're here to serve me. And I on the basis of gender, not necessarily race, because I have no comparators there. It's not as though there's somebody else you can say who's a white person who's in that position that he's not asking to do these things, like two people who are equal and he's only asking the Asian woman to do it. Clearly that's evidence, right? But in the absence of that, then the question is, how is that, in and of itself, and I mean, even in the totality of the circumstances, how does that get to the issue of being, why is that in such a pivotal fact for you when that is the person who's most responsible for taking care of his needs?
Your Honor,
as the head.
My response is, when you consider that factor as well as everything else, and I'm not saying, separately as a disparate treatment claim, that would be a claim, but in the totality of the circumstances, all the facts that she's alleged, that's at least a jury question. And if the jury says, looking at this.
At least a jury question as to the hostile work environment?
Yes, Your Honor.
Not as to the disparate treatment.
Well, Your Honor, the disparate treatment is also, she alleges that this performance evaluation that she received on February 15th was false as well. His overall assessment of her. Yes, so I think it is, that part of the claim is a disparate treatment claim. And as well, she was terminated. Her position is, I didn't resign, that hadn't been resolved, but you picked a date and decided that I was, that my resignation date is March 4th. Yes, there was some discussion about March 4th or March 17th or 18th after the board meeting, but there was no final definitive decision made on the date that she was separated. He decided that her last date would be March 4th, effectively, constructively discharging her on that date, when at the time she had an application for FMLA pending. I'd like to reserve just a couple of minutes for rebuttal. Thank you.
We will give you a couple. Thank you.
Good morning.
Morning.
I first want to get to this issue about the question in the deposition, and he didn't know the answer. So this is actually from from plaintiff's brief. I just want to read the question because it says everything. The question was not, did someone tell you about the FMLA leave before you sent the email at 5:40 p.m.? That wasn't the question.
So do you want to point me to a page of the, I assume we're in the Levis
Page
deposition?
23. I'm sorry, it's his deposition is,
It's in the JA 250 or so. So you're telling
Yeah,
me
so
page
the-
23 of the transcript?
so I'm reading from their brief, Your Honor, right now, but the deposition quote from their brief is in his deposition, page 80, line 20.
Got it.
But this is it. Question, you indicated that you learned from Ms. Davison that she requested FMLA leave. That's the 618 email, right? Did anyone else communicate to you that Ms. Davison requested or inquired about FMLA leave? And he says, I don't recall. So he had already testified, I heard from her. And he heard from her at 6:18, 38 minutes after he sent the email. And the question is simply, did anyone else tell you? Not did anyone else tell you before. Did anyone else tell you? And he said, I don't remember. Well, we're in a lawsuit. Of course, by the way, I discussed it with him at some point, right? We got ready for his deposition. His general counsel, I'm sure, discussed it with him. Kevin Madden on 618, who also testified, I didn't know he was the head of HR. I knew nothing about this FMLA leave. He sends an email to the HR department that says, what is she talking about? Right as soon as he gets it that Friday night. And they respond back to him. I'm sure Kevin Madden at some point afterwards told him. So this is not at all equivocating on the issue of who first told you. He already said, she's the one that told me, right? And to the issue about process, Judge Washington, you raised, Flora Oliphant testified, I don't tell the manager of the employee who's applied from FMLA until we're ready to grant it. That's my process. Who's the manager here? Dr. Levin. Exactly in process. So they asked Kevin Madden, they asked Colleen Coyle in depositions, did you tell? The answer is no, we didn't know. The only person who knew was Ms. Oliphant and her subordinate in HR, who no longer work for the organization. There's no evidence she did anything with that. There's no forward email. She didn't tell anybody. So this is just like the Kolowalski case, which is an employment retaliation case on the exact same issue. Did the decision maker know? And you can't just, you can't just not believe them, right? I have a hunch they're not telling the truth. Like that's not, at summary judgment, that's enough for an allegation. That's not a bad faith allegation in a complaint, right? But at summary judgment, you need evidence. So I just wanted to get to that issue about the question. Also, she never applied for FMLA leave. She inquired about it. That's protected activity. I'm not saying it's not. But this issue is she applied. She actually never submitted the FMLA application in the next 2.5 weeks she was there, whatever that was. And there's case law that when you're fired for a reason other than your FMLA leave, that's not an interference with the idea that if you had stayed, you might have taken the leave, right? It's not like you apply for FMLA leave and you're protected from being terminated or resigning here for other reasons. I mean, that's clearly the law. Now, on this discrimination point, of course, if the court has any questions about the FMLA issue, I'm happy to, right? On the discrimination point, it is undisputed that he walked into that meeting with no intention to fire her or no intention that she would ever leave, that she was going to leave as a result of what happened in that meeting. And there's tons of case law about the issue that a 3.82 out of 5 on a performance evaluation is not an adverse action or materially adverse for a retaliation claim or anything like that. The service issue, I think the trial court said this, she's there to serve the constituents, maybe not to him. And so he didn't use a great term there. I think we all would agree with that. But the context, which she admits, it's undisputed, is that he put these communication issues in her review into the customer service section. That's just the section to him that seemed most applicable looking at the form in front of him. And so he was explaining to her why she got a lower score on these communication issues within that section. Again, she doesn't dispute that. Both sides agree. He's talking about that section. And so that's the context for him saying, I'm the customer and you are going to serve me. And it's also undisputed she got very upset at that, but there's no indication that that's tied to anything other than her position and this communication problem, which
That ultimately, I mean, I don't know if there's enough other stuff, but isn't that the sort of thing that a jury would decide what it means in context?
No, I don't think so, Your Honor. There needs to be, one of the elements of this claim is there's got to be some connection to protected classification if we're looking at a hostile work environment claim. And the clear issue here is that she was in that role. Also, just for the context, right? She admitted that after this big argument in the garage, which was about how much to pay, by the way, an Asian American doctor, and he wanted to pay him more, right? They got this big argument, pandemic hits like 2 weeks later, and their relationship started deteriorating. She admits all that. And you look at the reviews in 2020, right after for the year of the pandemic, it's we never got back to our prior level of a high functioning, close relationship, which they had for 7 years, also admitted undisputed. We never got back to it once we started working from home. And then in 2021, right, the review for the 2021 year, we're still not there. And he puts a lot more in the review about we're not communicating. He keeps saying, I want to communicate better. I want us to get back. Then the next year, that's the year when they have the argument, right? He puts this whole thing in there about their lack of communication. So the context for this is right there. And none of it has anything to do with any protected classifications. And on this donuts point, okay, the cake or whatever it is, and this is they admit this is her job responsibilities, includes the annual holiday party, the staff lunch and learn, and other employee activities. I think counsel said it's not part of her duties. It's literally in her job description, which they admit. And she did that 4 times in the last 2 years. So even if that was somehow inappropriate and somehow related to other thing other than her position, it's 4 times in 2 years. And so for some context for the honey comment, he testified in his deposition that he's from Australia, and not on my watch honey was something his mother used to say when he was growing up as a child to him. Now, whether you should be saying that, 70 years later in a workplace, different story. But she testified. He said it once in the last 2 years she worked there. Hardly severe and pervasive. Even if I would argue that's not even based on, I mean, it's gender related.
Well, this is one of the problems I'm having, counsel, is distinguishing. It seems like the same evidence is being used for the disparate treatment and the hostile work environment, right? The termination, the unlawful discriminatory termination, and the hostile work environment. I'm not sure exactly how to parse these things. That's why I asked the question of counsel about the hun comments and the donut comments. Does that go to, the disparate treatment and as based on gender and her ultimate termination, right? Or does it go to a hostile work environment claim more generally?
And
the trial court treated it sort of as both, right? And relied on it, and found that it wasn't enough on both.
that's right. And it wasn't enough because there wasn't other than for the hun comment or honey comment, that one comment in 2 years for the sex harassment claim, none of it related to sex, and it wasn't severe or race, and none of it was severe and pervasive. So on appeal, they don't make a distinction in their brief. I read that as relating only, they talk about direct evidence of discrimination. That is a term that is generally used or really only used in the context of disparate treatment, right? Because in a harassment case, it's about conduct based on a protected characteristic. It's not direct evidence. They also say this, they also use without any citation that this conduct all explicitly references race and sex. I think none of that is true, right? I mean, the record is, and the trial court found that the only comment that has anything to do with any particular characteristic is this honey comment. So, Your Honor, I think the way they also don't argue the severe and pervasive, and they don't raise an issue with the trial court on that in their appellate brief, which I think takes care of the hostile work environment claim. I mean, if you don't dispute it, right, on appeal.
So you're saying they forfeited the hostile work environment claim?
Because they don't dispute the judge's ruling on severe and pervasive, trial court's ruling. Your Honor, the way I read it is that it's evidence for the disparate treatment claim. That's the way it's positioned in the brief, as direct evidence or indirect evidence of discrimination. First of all, I don't think it is that, because none of it has anything to do with race or sex. But secondly, it's indisputable that he didn't want to fire. He was not looking to fire her. She admits that. And second, we're back to this issue. She said the word she said. It's undisputed. There's a quote in her deposition that, well, I can leave on March 4th, or I can stay through the March 12th board meeting if I get a severance. And this issue about it had to be finalized, like there's no law about that. And there's no evidence in the case that other people have done that, and it was, taken, it couldn't be formalized until there was an agreement. The undisputed evidence is that she admitted it would look bad for him if she left before the board meeting, right? She admitted that. And so he knew, they both understood that. He interpreted the severance comment to be, well, she's trying to make, my choice is I look bad or I give her a severance. That's the choice she's given me. He was offended by that, and so he chose March 4th. There's no evidence otherwise. The fact that she brought in cake 4 times that's in her job descriptions is not evidence that she said that and he made the decision. I mean, he had 2 choices. It's either the 14th with paying her money or the 4th without paying her money and taking some embarrassment for your chief of staff. She gave him that choice. Choosing one of those options there's no discrimination there. And also choosing one of the options, I don't think is an adverse employment action because she voluntarily resigned. And there's law from this court, I think it's a 2007 case, where in that case, I think it was the sewer authority, right? DC Water and Sewer Authority, the Watson case, where somebody resigns and then they take all these steps to take it back 3 days later. They try to get it rescinded and they say, nope, you said it, it's done. And the court said, that doesn't make it an involuntary action because you try to rescind it. Here, she never tries to rescind it before he makes that choice. Not like she comes back to him and says, you know what, I got heated, I misspoke, I don't mean that. And he said, no, you said it March 4th. It's 3 days of silence. He's stewing over this issue that she's trying to really extort him for a severance or embarrass him. And he says, you know what, March 4th. And even then, she doesn't really rescind it. She says this comment about, well, I didn't formally resign and I applied for FMLA, which Judge Deal, I think we all know what's going on there, right? Which is she applies for FMLA because she knew what she said. But we don't need to that's what's really happening, but we don't need to get into any of that. I think the law is clear on the much higher level elements here. I'm gonna keep talking if you don't need me to. So any questions? Happy to answer, of course. Oh, can I make one other point with this? He said that Asian Americans are not entitled to protections. What we're talking about here is this question in the second half of 2020 about the listening sessions. Should he do a listening session for Asian Americans? He had done a listening session in the wake of George Floyd's murder for African Americans. And it was, well, do I do one for everybody? Do I do one for particular groups? He never did any additional ones. And that was, which is not an appeal, that in exchange is what was underlie the retaliation claim, which is again not appealed here below. So that's the context for that. It's not just, I don't think Asian Americans are entitled to protections under a statute. It's in that context. Okay, thanks.
Thank you very much. And she'll give you 3 minutes on rebuttal.
Yes. So the first point that I'd like to address is this claim that somehow she was fired for a reason other than the FMLA. So it's not disputed that at the her requesting FMLA, it's not disputed that at the time of her termination, she had initiated contact with Human Resources to begin FMA leave. And the next step in the process was just submitting the paperwork from her doctor. So the danger in this, agreeing with the APA's position, is if an employee submits a request for FMLA, it gives the employer the option of terminating that employee or taking action against that employee between the time that the FMLA request is received and when it's actually approved. And it gives the employer an option of terminating the person without any type of liability. That seems to be what the defendant is advocating for.
He's very clearly taking the position that the mere request for FMLA, that is protected activity that could be the basis for a retaliation claim. You guys aren't, there's no legal dispute between the two of you on that.
Just factually suggesting no application had been actually filed, clearing the record that in this case, no application was filed. You don't disagree with that, correct?
Well, Your Honor, she contacted.
No, I'm not. As Judge Deal said, there's no room. I believe, I may be mischaracterizing and I'll sure my colleagues will tell me, but I believe counsel said that he is not disputing that at that point, if there was evidence that she was terminated in retaliation for inquiring about FMLA leave, that would be actionable. Okay. But he raises, and I wanted to, and I was going to, but I thought I'd do it in your rebuttal. I also am aware of the Watson case. How do you distinguish what happened here from the Watson case? Why isn't Watson somewhat persuasive, very persuasive on the issue of her resignation slash request for a termination date?
Your Honor, I'm familiar with Watson as well. That was my case.
Yes, I thought so. That's why I was waiting. For rebuttal. But
Your Honor, the distinction between this case and Watson is that Watson submits his resignation. He leaves work that day. He doesn't do anything else. And then days, or I think it was a few days later, goes home, talks to his wife and decides, hey, I really didn't want to resign. And then he goes back and tries to undo what he's already, what he had already done. That's not the case here. What actually happened here is that there was a discussion about her resigning, and then she was to meet with someone, human resources. And then even when on February 18th, after she gets the response from Dr. Levin, she says, hey, I've already submitted my FMLA paperwork or initiated the FMLA process. I have 600 hours.
But I guess the question is, the theory underlying Watson was you can't take it back. If you go in and you offer to resign and you say, I'm going to resign on this date or that date, you can't then later on say, oh, you know what, I've changed my mind. I'm not going to resign because at that point, isn't a part of what underlies that case the idea that who would trust you? If I go to you and say, look, I'm resigning this day, or if you pay me more, I'm staying to this date, right? At that point, why would the person, when you come back to them and say, you know what, I changed my mind, I'm going to stay, why couldn't they fire you? Because, right there, the trust is broken, especially in a position like chief of staff.
Your Honor, what I will say is what distinguishes this case is this conversation took place during a performance evaluation meeting that was not completed. And so there was a follow-up conversation that was scheduled, I think, for the 22nd to continue the discussion on the performance evaluation. In the heat of the moment, Ms. Davison, made this statement, but it was far.
Why don't we say in Watson, in the heat of the moment, he resigned, and then he went back. His wife had him think about it, and he went back.
Well, there was for Ms. Davison, she continued to work after February 15th. Well, she was on leave for 2 days, and then February 18th, she had this exchange request in FMLA. But she was scheduled to go back to work on the 22nd to continue working, continue the performance evaluation meeting. It's not an immediate action of resignation. Here's my resignation. Yes, I'm accepting your resignation. That's the end of it.
That had been the case on that day. You're saying that she would not have had a claim that his decision to accept it was discriminatory?
Yeah. If during the course of the meeting, she said, I'm resigning on March 4th, and he said, absolutely, your resignation is accepted effective March 4th. And, I think that concludes the matter. So
you were claiming she would not have had a discrimination claim then?
Well, discrimination is a different issue.
Okay, so she would not have had a family medical leave claim, is what you're saying?
Yes, I believe she would not have an FMLA claim, although she's basically saying that she was, constructively discharged when.
That's what I was asking you. So it is still constructive? So, okay. I think I understand your argument, and I don't want to take up all your time. Thank you. I'm sorry.
And the final point was I was just going to raise the issue about the Watson case. So that actually addressed the issue. Thank you. Thank you.
Very much. Thank you for your arguments today, and the case will be submitted. The third argument on this morning's calendar is number 24 CV 718. In re Matthew Joseph Ricciardi.
Good morning, Your Honors. May it please the court. My name is Matt Ricciardi. I find myself in the awkward position of being both counsel and client today. So,
Sorry, I mispronounced your name, Ricciardi.
not at all, Your Honor. I get it all the time. I'd like to reserve 3 minutes for rebuttal, if I may, please. This appeal is most remarkable for what the district doesn't argue. The district.
Mr. Ricciardi, would be helpful to me if you tell us what you are arguing first. And the reason that is because you have the burden, correct? Not below,
Not
but
below.
you're on appeal.
Correct.
Okay, so you have to tell us where there was error.
The agency was wrong to read the calibration statute authorized under the automated traffic enforcement statute as eliminating the margin of error as a matter of law.
And the question that I have as an initial question is, where do you find in the record that there is a margin of error?
Yes, Your Honor. I can point you to 2 places that were before the agency.
Okay.
So if we look in the appendix to the brief, page A10 of the appendix, this is the deployment log, which the district submitted to the agency, and it's discussed in the agency's opinion. Line item B1, is the reading accurate to plus or minus 1 mile per hour? Answer, yes, plus or minus 1 mile per hour.
Whose statement was that? I'm sorry.
The certifying official who certifies that the camera is operating.
Yeah, that was his testimony.
Yes, and so he signs in the middle of the page, operator name and his signature is there.
Right.
So he's the certifying authority, yes. And that's not just my reading, that was confirmed by the agency. So if we turn now to the hearing record, which is on the very next page of the appendix, it's the first line up from the bottom. The hearing officer, Ms. Boyd.
I know the hearing officer makes a statement that about plus or minus. You consider that to be a finding of fact?
Statute, yes, Your Honor. And this is a point that I make in my brief. The ATE statute says that technical matters or matters within the particular knowledge of a hearing officer are judicially noticed facts. Now, normally you would expect the district to rely on them, but here I'm relying on her agreement with the deployment log plus or minus 1 mile per hour criteria. And I don't recall the statutory citation, but it is in my brief.
Right, no, it is. I agree. So your argument is that her statement is a judicially noticing the fact of the plus or minus 1. Okay, and okay, thank you.
And that's consistent with the deployment log, which is also in evidence before the agency. I would also note that the agency does not dispute, and this goes back to the deeming something as a matter of law. I don't read the agency's briefs or arguments below as disputing that as a factual matter, there is some margin of error, right? There's some margin of error, and plus or minus 1 is the only margin of error in the record.
Can I ask you the question a bit about that? Because it goes back to the deeming issue. Because I'm trying to figure out how do we weigh that? Certainly legislatures and administrative agencies deem factual matters, and they are, as a matter of law, recognized by the courts unless clearly erroneous, meaning there's no factual basis for their decision to deem as accurate, for example, in this case, the speed that you were traveling, right? So if that is the issue and there's no evidence in the record for us to evaluate whether the legislature's determination of accuracy is true or false, then how do we in this review get to the issue of whether the speed that you were traveling on the NOI is accurate?
So with respect, Your Honor, the premise of your question is wrong. The deemed language is not in a statute enacted by the legislature.
Well, it's in a regulation.
It is, but this is a critical distinction that's called out in the briefs. The authorities cited by the district for the proposition that the legislature can create a judicial, deem something to be a fact. Those are all in statutes by the legislature. They don't cite any authority, and I found none, for the notion that an agency can meet its statutory burden of proof by regulating its own evidence to be perfect. That's what happened here. That's their argument anyway. That's how they read the calibration statute. And that's how they avoid the margin of error problem. They say our own regulation deems our own evidence to be perfect, and therefore there's no margin of error.
So how do we, I'm trying to figure out what the material difference is between that being deemed by a legislative body and that being deemed by the agency responsible for administering the statute. Is this go back to a problem with the promulgation of their regulation? Or is this, and then how do we in this record review that?
So I don't know that there's a problem with the regulation on its face. The regulation on its face doesn't say anything about creating the legal fiction of perfect accuracy. It says deemed to be calibrated, and this is in statutory appendix at S2. It says deemed to be calibrated correctly and in proper working order. That's it. And then it goes on to say that is true if it's plus or minus 1 mile per hour. So I think
Tuning fork, if it's plus or minus 1 mile an hour to calibrated to the tuning fork, correct? All right. And then it goes on to talk about, is there nowhere in the statute or the regulations that talk about the NOI, the accuracy of the speed that the gun, device measures you? Yeah, the photo device measures you.
well, so there is in the regulation at the part we're talking about. In the statute, none is cited.
No, I know, but in the regulation.
I'm not aware of anything other than what we're talking about.
Can we, I thought you were going to point us to 3012.6. The notice of infraction shall constitute prima facie evidence.
That was going to be my next point.
But before we even get there, why don't we just talk about 2209.01 in the statute, which I think the district is also relying on in
It
terms of
interplays with-
yeah. So I mean, I kind of want to. It's a curious clause in this statute. It says recorded images taken by an automatic traffic enforcement system are prima facie evidence of an infraction. I find that curious in the following sense. You know, a picture of a car or a video of a car traveling is. I fail to see how that could possibly be prima facie evidence of an infraction. You need something more. You know, if you look at the notice of infraction, there is some data on there. It shows you speeds. And then so the question is sort of, is that a recorded image? Well, I don't really think so. It's sort of computer generated data that shows up as part of an image. It's strange. But I mean, what's your interpretation of this statutory clause?
Yeah. So, well, first of all, there's the statutory clause that talks about prima facie evidence, the one Your Honor is quoting, and there's interplay with 3012, which I'll come back to next,
Right.
Because they both address prima facie evidence.
Right.
And you're absolutely correct. They say different things. And I think that's an important distinction. So as Your Honor noted, the statute refers to the recorded images as prima facie evidence of an infraction. It makes no reference to the notice of infraction or the charge in the notice of infraction. I read this to mean that the recorded images are prima facie evidence of whatever infraction they actually evidence. And to Your Honor's point, how do you get there? I think in fairness, I read the data as part of the recorded image. It's part of the record because otherwise Your Honor's correct. It makes no sense. It's just a picture of a car. So if we look at the notice of infraction.
It could make sense. It could be, this could just be an authenticity statute. I mean, I know the district has a response to that, which is, well, then you're reading prima facie evidence as in a sort of odd way and you're reading it as surplusage. I don't know. I don't know if legislatures really mean sort of legal prima facie evidence in such a technical way as we're talking about it as being therefore sufficient to carry one's burden. And because if you read it that way, then this is just a nonsensical clause. And so maybe they just didn't mean it that way. But you're going to talk to me about the regulation as well. And here we're at 3012.6, right?
Your point about authentication is certainly possible, and I do make that point in my opening brief. The district has a response. Certainly, I wouldn't dispute that if that was how the court was inclined. So if we look at the notice of infraction, which is on A8, the data there says limit 050, meaning the speed limit was 50 miles an hour, and speed 061, meaning 61 miles per hour, 11 over the speed limit. The crux of this case is whether the agency's own calibration statute renders that 61 absolutely perfect Or does that mean 61 plus or minus 1, consistent with the agency hearing officer's interpretation of the deployment log? That's the crux of this case.
Right, and where's the evidence that it's one or the other, and how do we weigh that? How do we determine that?
Well, below, the burden is on the agency, right?
And they have prima facie, but they've got a statute that accords that prima facie evidence bound, a weight to their recording unless we decide that somehow that's, they didn't intend it or it's nonsensical because it's for the reasons Judge Deal has already suggested.
Right. So,
But let's assume for the sake of argument, it's not. And then the question is, well, what do we do on appeal with nothing else in the record? You know, nobody who's come in and testified that this means this, or this is inaccurate way of evaluating, or this is a more accurate way of reading this.
well, I would say two things. One, prima facie evidence shifts the burden of production, right? So then the onus is on me to come in with some reason to doubt that evidence.
Right.
I've done that in the two ways I talked about before. The agency's own statements about its own devices having a plus or minus 1 mile per hour sure seems respectfully to me like a pretty good production of a reason to doubt the fact that it's perfectly legal. And again, it would be different if the legislature created that presumption of legal perfectness, but the agency did it itself about its own evidence.
Where is, you said you weren't able to find any cases where where an agency was able to do that. Did you find cases where an agency was criticized for doing, or was found to be outside the purview of an agency's authority to do such a thing?
None either way are in the record here. The cases cited by the district and relied upon both involve the legislature
Right.
enacting statutes, which is
Right.
not the situation here.
Correct, but there's nothing that says that a administrative agency cannot.
I am aware of no such authority. Perhaps it's a question of first impression for this court. I would submit that if an agency can declare its own evidence to be legally perfect, that does seem to undermine the statutory burden of proof.
Right, the statutory, the 2302.06, where it says they have to prove it by clear and convincing evidence.
Precisely.
If they can say, and we've done that by, just by virtue of you having received an infraction, that would seem to be a conflict with the statute.
Exactly
Okay.
so, Your Honor, that you articulated it better than I did, but that's exactly the point. It's inconsistent with the clear intent of the statute. If Your Honors have no further questions, I'll reserve time for rebuttal.
Thank you.
Thank you.
Thank you. We'll hear from the district.
Good morning, Your Honors. It may please the court, Amber Greenway for the District of Columbia. So Judge Deal, I want to start with your proposition about your inquiry about the statute itself. So in the statute, as the provision that you pointed out, it says recorded images taken by the ATE system are prima facie evidence of the infraction. When we look to the actual notice of infraction, it includes the recorded images that are actually captured from the speed unit camera here. So at the top, it has that black bar that Mr. Ricciardi was reading from. That is an actual screen capture from the speed unit camera that lists, and it takes it in 2 different points in time. And if you have that up, if you can tell looking at the time. So the time says 24:14, 24 is the minutes, 14 is the seconds, and then 0.4, which is the fraction of the second. So it takes it at that fraction of a second. Then the second snapshot is from the 9th fraction of that 14th second. So it takes it at 2 different points in time and registers Mr. Ricciardi's speed at 61 both times. So if we're just looking at the statute, not looking to the regulations at all, that would be prima facie evidence that Mr. Ricciardi was traveling at 61 miles per hour in the heightened charge range.
I don't want to get too bogged down on this because I think Mr. Ricciardi has largely sort of conceded that that's part of the image, at least in oral argument, he seems to accept that. But I suppose my question for you is, do we know when this statute was passed, if that was part of the images that these photo cameras would produce? I mean, if I were a legislature and I said, you know, photos that are taken by these things, they don't need to be authenticated. They're prima facie evidence of whatever they show. I would not think, and that includes whatever machine-generated statements the district wants to design these cameras to also generate and stamp into the image, even if they show up on the screen of the camera. So I would, as a legislature, I would be, well, that's not a recorded image. That's machine-generated data, is what I would think. And do we know when the legislature passed this statute if this is what they look like?
Your Honor, I actually do not know.
That's a very detailed question. There's no reason why you should know.
Oh, yeah, I promise. I don't know that.
So let's talk about what Mr. Ricciardi's principal position is. Okay, you have some prima facie evidence. If nothing else were in the record, you got them, 61 miles per hour. But we have evidence in the record that the calibration it's calibrated to plus or minus 1 mile per hour. We have a finding by a hearing examiner saying it's plus or minus 1 mile per hour. And therefore, the best we can say on this record is he's going somewhere between 60 and 62 miles per hour. You know, 50-50 shot, it's over 61.
So, Your Honor, I think you're getting at our secondary point about whether or not the regulation actually refers to the actual speed that the camera registers. So here, and the board explains this in their decision below. The testing of the regulation refers to the testing of the unit, not the actual speed that the camera registers. And so here, there is no evidence in the record from which we can conclude that there is a margin of error. And this goes to Judge Washington's point. There is no evidence that we can conclude that this particular camera also had the same error range up to plus or minus 1.
Can you agree that it has some error range?
Absolutely, Your Honor.
So no matter what that error range is, it will put it at 50-50 that it's over or below 61.
No, Your Honor, because that depends on, this is very technical and very on the ground, but from my discussions with the DMV folks and how this works on the ground, is that there's no evidence that there's an error, a margin of error that's kind of equally distributed on both the 60 side and the 62 side. So it gets kind of very nitty gritty in terms of the particular manufacturer and the model.
I mean, you guys are the only people in possession of that information. What do you want him to do? I mean, he asks for the information. He gets, what do we have at the evidence log at A10? We have your certification, and all it says is plus or minus 1. It could have said only plus 1. We're calibrating this low so that any error will be to the benefit of the person who gets ticketed. We put it at the very bottom margin, and all errors will be above whatever they're ticketed at. You could have said that. So I guess I'm just wondering what more they can do other than rely on your own statements that it's a plus or minus 1 calibration.
So 2 points in response to that, Your Honor. So first, as to the promulgation of this particular regulation, prior to the prior regular version of this regulation for the calibration was specific to one particular manufacturer model, and we outlined that in our brief, and it had a similar error range of 36, 37, 38. In recognition that the district was deploying different units that had different accuracy criteria, they enacted this regulation of plus or minus 1 that was not specific to any make, manufacturer, or model. And so that is to encompass it, and that was an efficient way. If the unit tested within those ranges, that is permissible based on the DMV's specialized knowledge on how these unit cameras work on the ground. And so to when Mr. Ricciardi raises this margin of error, that is the problem here. The margin of error is and the court and the DC Council has made clear, and the DMV has made clear in this regulation, it is not specific to any particular camera. So there is no evidence that this camera also has that
question's
margin.
Back to what do you want them to do?
Well,
why does the district know which margin of error this camera had?
Well, no, Your Honor. So kind of two responses to this. So what do we want Mr. Ricciardi to do? So he has a number of discovery mechanisms that are available to him. The board points out, and it's also in the notice of infraction, the deployment log that Mr. Ricciardi now points to is included in the notice of infraction. He can log onto a link, put in a PIN, and this deployment log is available to him. He then has a method of means and discovery means at his disposal to get this information about the particular margin of error for this particular camera. He chose not to. He chose to solely rely on a regulation that a DMV has made clear is not specific to any camera.
I'm sorry, just pause for a second?
Sure.
What's his option to get this particular camera's margin of error? Where do I see that?
Sure. So it's outlined in the regulations, but it's also talked about in DaVita, and it cites the applicable regulations. So I can give you that quick spiel. So in DaVita, this court said
All right,
that
rather than a spiel, can you point me to a citation in the record that says anything about how he had an opportunity to get the particular calibration of this camera?
oh, well, the board talks about it and it's in their opinion, Your Honor, A4 through 5. So there the board cites that Mr. Ricciardi had an opportunity to discover additional information and chose not to. Again, on motion for reconsideration, the hearing.
I'm sorry, that's just, I'm at A4 and 5.
Sure.
So you're gonna,
To that with you.
you're gonna point me to the spot where they say you could have gotten the precise calibration of this camera. Is that right?
Second, Your Honor, I'm going to turn to that with you so I can follow along. Oh, no, Your Honor, it does not say that. So here it talks about how this information was discoverable, and it says that Mr. Ricciardi did not proffer any new additional evidence. And again, also in the hearing exam.
So the deployment log and any other evidence desired was also discoverable. Is that what you're pointing me to?
Yes, Your Honor. And the hearing examiner also talked about how Mr. Ricciardi did not submit any new or additional evidence about the calibration of that particular unit, and that's at A11.
I just want to know how that information would have been made available to him. And I hear you telling me, yes, it's definitely available to him. He can get it. And I just want to see where I can find out that if that's true. That this camera, that somewhere the district has this camera's particularized calibration, whether or not it's plus or minus one, if it's only plus one, and that is information he could have procured. I hear you saying that. I just want to know where it's coming from. I don't mean to derail you. If you want to go on to a different
No,
point,
no.
I'm happy to give you a chance.
To make sure that I answer your question, Your Honor, I know that we cite the particular discovery mechanisms that are available in our briefing, and we cite the relevant regulations that are available there. It's a part of the statute. When you click on the link, it has the notice of appeal. The notice of infraction includes a link and a citation to the statute that has his rights to have a hearing. That's also in the hearing examiner's record.
I mean, one thing that the hearing examiner says, the hearing examiner seems to take him at his word, that's plus or minus one. You know, that's the final conclusion of the hearing examiner's ruling, is it also could have been plus one. So maybe he was going 62. So it seems like we've kind of got a finding of fact that this has a margin of error. Based on the best evidence that I have in front of me, is it's probably plus or minus one. It's not definitely. I get that it's just a regulation, and we just say that it's somewhere within there. But I don't know. Do you want me to just assume it's only cutting upward? And I don't know why I would assume that as opposed to it only cutting downward, or as opposed to it probably being, you know, margin of errors usually go in both directions. It seems like a safe bet that it's going up and down.
So
Is that the reason why it's deemed to be accurate? Because there is this evidence that it is close to being accurate, and it is sort of a legislative, or in this case, administrative way of addressing these anomalies where it could be on one or the other side of one or of a dispositive number.
That is exactly correct, Judge Washington. That is why we have this operation of the statute. And so this and that presumption of that evidence of relying on this photographic image comes from the statute, not the regulation. But I would also like to point out that the regulations here, the charge range and the speed tables, is also promulgated by the DMV. So to the extent that there is some interpretation of the statute that is in conflict, that is not present here. Here, the DMV was issued a regulation that corresponds with the penalty table that it itself also promulgated. So here, there's no kind of cross statute regulation overriding the statute. That is just not an issue here. But to Judge Washington's point, that is how this works. And this is the exact issue that was brought up in Agoma, and we cited that in our brief as well. And in that case, the driver was clocked speeding and made the exact argument that this camera registers whatever the registered owner is they are deemed to be the driver. That is the rule of evidence that was set out by the statute, the ATE system. The driver there challenged that and said, the district cannot prove by law what it cannot prove in fact. And this court soundly rejected that in Agomo and said, this is just a rule of evidence. It is an evidentiary presumption. That is exactly the case here. If the unit is properly calibrated and certified to be in working order, then whatever speed is clocked on that camera is treated to be prima facie evidence that Mr. Ricciardi was in fact traveling that speed, and then it becomes his burden to proffer countervailing evidence.
No, what's different, so you guys cite, I believe, Agomo and Rogers as your two best cases for this sort of statutory.
And DeVita, Your Honor, I'm so
And
sorry to
DeVita.
interrupt DeVita
That's okay.
as well.
All cases that, from what I can tell, are where the information that would be necessary to rebut the fact is uniquely within the possession of the person being cited or charged in Rogers, which was contempt. So if they say, look, this is your car, we're ticketing you. For you to come forward, it seems like the only person who can dispute that and say, actually, no, somebody else had my car would be the person who was cited. In Rogers, I believe the case was something about contempt and failure to pay child support. And they say, well, anytime you don't pay child support, that's going to be deemed willful unless you can kind of come up with some explanation for it. Here, it's very different to say, you need to show us what the plus and minus on our cameras are. It's deemed accurate, even though when the best thing the district can tell us, all you guys are producing is that all we can say is it's plus or minus 1 miles per hour. And if there's any margin of error, I mean, if it's a plus or minus margin of error, it's just as likely to be above or below. So that seems like information uniquely within the district's possession, not within Ricciardi's.
So 2 points in response to that. So first, factually, Your Honor, the information regarding the deployment unit and the particular calibration of this specific unit is within the possession of the district, but is automatically given to the driver in the notice of infraction when it is issued. Here, there's no evidence that there's even a margin of error. And I'll turn to, and I want to point out to the deployment.
I thought we already agreed there was one.
Well, no, Your Honor, there's no evidence of a margin of error, Your Honor.
But I thought we already agreed that there must be one.
Well, there's no evidence to the degree, Your Honor. I'm sorry.
Sure.
To be more specific, there's no evidence that it corresponds to the plus or minus 1 error range, Your Honor. So it could be, in theory, more precise. We just don't have that information. And to Judge Washington's point, that cuts against Mr. Ricciardi, not the district. But here, if we look at the readings on the deployment log, the reading here says it was set to frequency for 4, and that's on A10, Your Honor. So the deployment log, and so Mr. Ricciardi cited to that statute, to the question below. But if you look at the frequency in the reading, it's 40-40. So there is no evidence that there is a plus or minus 1 error range here, and Mr. Ricciardi has to rebut that. But also, if we're looking to Your Honor's point about kind of, I think, Your Honor's intimating at reversing the burden of proof, and that is not what's happening here. And in DeVita, that was a speeding ticket case, Your Honor. So there was no kind of additional.
Remind me what the fact was in DeVita?
Sure. So he was issued a $50 fine, and he challenged it on constitutional grounds and said that this prima facie evidence flipped the burden of proof and absolved the district of meeting their heightened burden of proof. And to that point, this is a direct quote from DeVita, Your Honor. Contrary to appellate's contention, he was not made to bear the burden of proof at his hearing. While the statute authorizing ATE system provides that recorded images taken by an automated traffic enforcement system are prima facie evidence of an infraction and may be submitted without authentication, respondent had an opportunity to rebut the government's prima facie case by offering evidence to the contrary. As we said in Agomo, there is no constitutional infirmity in the code provision that declares recorded images to be prima facie evidence of an infraction. And that is from page 723 in DeVita, Your Honor. So this has already been addressed by this court.
Ms. Greenaway, can I ask a question? So let's assume for the sake of argument, Mr. Ricciardi had come in and testified that he knows he was going 60 miles an hour. He was not going 61 miles an hour. He was looking at his speedometer and he was going 60 miles an hour. Would that evidence have had to have been considered by the hearing officer
Absolutely, Your
And
Honor.
then the hearing officer would have had to make a determination as to whether she believed him or not, correct?
Absolutely. And there's other methods. I know a lot of drivers use speed camera GPS trackings on their phones that clock speeds and speed cameras and the like. And so all of that evidence would have been presented to the hearing examiner in the first instance. Mr. Ricciardi presented no factual evidence as to his actual speed, as to the actual margin of error for this particular camera. He solely relied on the regulation. And if this court finds that we complied with the regulation and the statute, that ends the matter because we have met our prima facie burden of proof.
So you're not conceding the argument made by Mr. Ricciardi and echoed up here that if there's a plus or minus one calibration to the tuning fork regulation, that's equal to plus or minus one in terms of accuracy of speed determination.
We are not conceding that, Your Honor, because there is no evidence that corresponds because it depends on the actual manufacturer and model and how they process error range. The frequency of that is very specific. It is very technical. So we are not conceding that would be a requisite here, and it's not supported by the evidence in the deployment log.
But you agree there is a margin of error. It is, for all we know, based on the evidence, just as likely to be plus or minus, right? There's no reason from what we have to believe that it's cutting things up versus down, or both up and down at an equal rate. It's just totally, the record's just totally silent on all of that.
Yes, Your Honor. And our point is because that record is silent on that inures to our benefit, and that cuts against Mr. Ricciardi because we complied with the regulation and statute of only issuing tickets on a properly calibrated and certified to be in working order speed unit.
And I think his response is that total unclarity means that you don't get to clear and convincing evidence that he's above 61.
So 2 points, Your Honor. So that our primary argument is that we've met our burden by operation of the statute. The statute simply says if we are, and how it reads in the regulation, the regulatory scheme, and the board read it to be this way, cited both the regulation and also the statute. So here, this is how the agency is interpreting these statutes and regulations to work in conjunction together. If we issue tickets from a properly calibrated and certified to be in working order unit, whatever speed is captured on that unit is treated as prima facie evidence that Mr. Ricciardi was actually driving that speed. That is our primary argument. So as a legal matter, we win. If we turn to the factual matter, there is no factual evidence that this particular camera has the same plus or minus 1 mile per hour margin such that it would be appropriate for this court to imply that Mr. Ricciardi was traveling somewhere between 60 and 62. We just do not have that evidence. And then to wrap that point up, if that lack of evidence cuts against Mr. Ricciardi because it is his burden below, once we've met our prima facie case, which we've done by operation of the statute, to countervail that evidence. He did not, and therefore the agency's decision should be upheld.
When you talk about margin of error, could the margin of error in this case been 61.3 to 61.7?
That's perfectly plausible.
He could have been gone 61.5 miles an hour.
That's perfect.
So he still would have been over 61.
Would have been over 61.
So it doesn't necessarily mean, even if there was a 1 point difference, one way or the other total, that he was doing less than 61.
That's correct. We just don't have evidence about how that error range was operating for this particular camera. And that's the issue here that cuts against Mr. Ricciardi, not the district. I'm happy to answer any further questions, but if not, I'll rest my papers. Thank you, Your Honors.
Thank you very much. Mr. Ricciardi will give you, I think you had 2 minutes and 2 seconds left or something like that.
Sorry, give my stuff out of your way. Sorry about that.
No problem.
Thank you, Your Honors. I'll be brief, really just one point. There seemed to be some confusion about whether the deployment log was particular to the camera at issue in this case. The reason I didn't request discovery from the district regarding the margin of error for this particular camera is because on its face, the deployment log is particular to this camera. It says site code 2624, antenna number 86206, which I assume is the antenna on the device. It has the specific street address of that specific camera on these specific dates. So I understood this to be the record for the margin of error of that camera on the date of the alleged
So there's
offense.
nothing else that would be found in seeking that information. So,
Well, I didn't put in the request because I thought I already had the particular information about that camera.
right. And is that correct?
I believe it is. Counsel seemed to suggest that there might be something more and that this was generic and not particular to this camera. I'm just saying, I don't think this is generic. I think this is particular.
Does the notice of infraction that identifies that camera and all that information or that you received identify it as having a margin of plus or minus 1?
So the notice of infraction includes a cross-reference and link to the deployment log, and the deployment log has the plus or minus 1 mile per hour language.
Okay. I think I understand that.
So this is the notice of infraction.
Right.
It has a box with a link, and when you
Right.
click on that, you get the deployment log.
Okay. And you did.
And I did.
And it did not, there was no evidence of any not calibration, but well, maybe calibration, but no indication as to the margin of error.
No, there is an indication. It's page A10 of the appendix. It says, is the reading accurate to plus or minus 1 mile per hour? Answer,
Well,
yes.
but that's adds to the calibration to the tuning fork, right?
Yes, but the tuning
But-
fork is this is a radar-based measurement, so it's measuring the rate of the oscillation.
Right. I'm not
Yeah.
disputing that. But what I'm saying is there any, I'm testing the government's sort of argument here. And I'm trying to figure out, similar to what Judge Steele was trying, is to ascertain whether if you do go to that deployment log for that particular camera, you can find the information and and when you did that, the information said this is accurate to plus or minus 1 mile per hour or something along those lines. And what I'm hearing is it's basically saying we calibrated it consistent with the regulations.
To an accuracy of plus or minus 1 mile per hour. I guess so I would make 2 final points. As a logical matter, if it's only calibrated to an accuracy of plus or minus 1, its reading can't be more accurate than
Right, and that's why I started my kind of questions with you with the deeming issue, because I'm not disputing that, but I am trying to figure out how and what our review can do under the circumstances. We can't reweigh, and that's why I was asking, well, what is the standard here? Is it clearly erroneous because their determination is not based on any factual, doesn't have a factual basis, or is it reweighing, which is, well, we hear what you're saying, but we're reweighing what the evidence in this case and find based on some evidence that you did not violate the statute, which is what you're asking us to find. And that's.
So I would say it's either clearly erroneous or it's contrary to law. That's another of the provisions you can review for. And the contrary to law is the region Judge Steele alluded to earlier, where it makes the heightened burden of proof in the statute evaporate if their evidence is perfect. And if the legislature wants to do that to itself, that's fine. But here it's the agency saying its own evidence is perfect and undermining the heightened statutory burden. So that would be contrary to law is another way to.
The administrative agency can't, in enacting the statute.
Regulation.
That's right. Agency enacting the regulation can't say that under, in interpreting the statute, this is what this means. This is what they mean by accuracy as to speed or prima facie case of violation.
Not in the way they've done it here, because it undermines the statute, right? If their evidence is perfect.
Undermines the statute. The statute
Requires.
suggests that it's not that. What is the statute? I'm sorry. How does it undermine the statute? I'm just curious.
Let's go back to, and I apologize, I'm over.
No. I need to understand your argument entirely.
So the statute has 2 provisions that we've talked about. One is that the recorded images are prima facie evidence of an infraction. And my argument is that they're evidence of the infraction actually evidenced by the images, not whatever one the district happens to print on the notice of infraction. The infraction actually evidenced by the images has to factor in the margin of error, which is plus or minus 1. But to your honor's question, section 2302.06 talks about the burden of proof, and this is again in the statute.
Mhm.
The burden of proof shall be on the district, and no infractions shall be established except by clear and convincing evidence.
Right, I get it.
If the Department of Motor Vehicles can say our evidence is literally perfect as a matter of law,
Well, they're not saying literally, they're saying clear and convincing. Perfect and clear and convincing are two different standards.
no, I understand that to be saying it's perfect, meaning there's the margin of error is literally zero. Because as Judge Deal.
I heard them say the margin of error, there is a margin of error, it's just not clear, it's plus or minus one.
Well, I think that's also dispositive then, because as Judge Deal noted, the margin of error is centered around the very bottom of the charged range. So if there's any margin of error, it would extend. below the
It shouldn't be
charged range.
61.5, and then the difference is between 61 and 62, and they cut you at 61?
Sorry, Your Honor, say that
If
again.
the margin of error is one, plus or minus one, right?
So -1,
And
that's
say
correct.
you were doing 67 miles per hour or 70 miles per hour.
That would be a different case.
Well, it may have been, but what, we don't know if the calibration was on the low side or the high side of what speed you were going. And the question is, again, goes back to the issue of, well, what is our role when an administrative, now we can, if what you're suggesting here is that we should, that the answer here is the administrative body that established the regulation did not have authority to establish that regulation because they established it contrary to law, then that's why I was asking for cases cited. If it's that we reweigh the evidence and we can determine that you weren't going 61 miles an hour, I don't know how we do that without any other evidence in the record. So you're saying, so again, I guess what you're asking us is to find that the regulation itself is contrary to law, and you're suggesting that it's contrary to law because it somehow is contrary to 2301.
It's actually both, Your Honor. In terms of reweighing the evidence, the record is not devoid of evidence. We have the deployment log ±1, and importantly, the agency itself acknowledging the ±1. So this is illustrated in the graphic on page 10 of my brief, where it shows that if the margin of error is ±1, because the measured speed was at the very, very bottom of the charged range, any minus error would put you outside below the charged range, and therefore they wouldn't meet their burden of proof.
Got it.
No further questions? All right. Thank you, Your Honors.
Very much. Thanks to both sides for your briefing and your arguments in this case, and the case will be submitted.